I think I'm just speaking on behalf of the chemical sector. Again, the value, the provisions that are of most value to us are not the ones that are in Annex D. It's very rarely do you see a physical direct expropriation of a chemical manufacturing facility. I'm not saying it couldn't happen, but the cases, the ISDS cases are not with respect to those types of violations. It's the indirect expropriations. I think a lot of other companies would value the minimum standard of treatment, fair and equitable treatment. The provisions that are available to the select sectors are of more value to, I think, a lot of different types of companies. It just depends on where you sit. It's possible that you could extract some value out of the way that Annex D is drafted, but for us anyway, we would have preferred to have access to the rest of the provisions.
I do think the exclusion I would echo what Ed is saying, that the exclusion for indirect expropriation I find to be very troubling. I mean, most governments these days, maybe with the exception of a few I can think of, don't just issue a federal government decree saying they're going to expropriate your property. It's more sophisticated and it's more complicated than that. And for heavily regulated industries, it often is through regulation that they lose the value of their investment, often with a discriminatory element. But whether national treatment alone can get to those breaches, I think is a big question mark. So I do think it is, it is a serious narrowing of this ability to enforce these protections for the majority of U.S. investors. The other thing, which I think you touched upon in your opening slides, is everybody else has to go to local courts for 2.5 years unless they can get a judgment sooner. At the same time, you need to bring your investment claim against Mexico within 4 years of having knowledge of the breach. So 4 minus 2.5. You basically have kind of an 18-month window to decide. You better quickly launch your domestic dispute action so you can wait that out in parallel to being able to possibly file an ISDS claim. I think that also puts U.S. investors at a disadvantage because one purpose of having this neutral enforcement mechanism is that if you don't think you can get a fair shake in the local courts, if you think it will be very politicized, then you have a neutral dispute settlement option. This forces you to spend 2.5 years in courts that you might feel are not going to provide you as a U.S. investor with that neutral forum. And as a result of all these squeezes, I think it squeezes those that are in heavily regulated industries. I think it also squeezes small and medium-sized investors. These are supposed to be investment protections for all U.S. investors. But to be frank, unless you're a big, sophisticated multinational company who is lawyered up from day one, how are you supposed to figure this out? You know you're not being treated fairly. You're trying to figure it out. Maybe you go to local courts. Do you even know you've got this 4-year requirement? So I think it also really disadvantages entire swaths of U.S. investors who are not big mega companies, but still might not get treated fairly by the Mexican government.
Over the years, some of the critics of ISDS have made the observation that by giving foreign investors this forum, you're discouraging them from going to local courts, and then that has the effect of disabling local fora from becoming stronger, more robust fora in which investors have confidence, and that the argument sometimes gets made that by having an exhaustion requirement, by forcing investors to start in local court, unless it's obviously futile, by forcing them to start in a local forum, you are you get this side benefit of strengthening the local institutions. Does anyone think there's merit to that argument?
No.
maturation of institutions that support market economies and that support democracies like ours are the product of long historical trajectories and many factors. Probably a very small, maybe even minute factor may be the way in which an investment chapter is crafted in a free trade agreement. I think that the extent to which free trade agreements can incentivize the further integration and interdependence of democracies and economies like we have between Canada, the United States, and Mexico, that provides a baseline that enables this whole host of other factors to allow for the maturation of something like the courts in Mexico. So I think generally our view is that it's the wider benefits that you want for a free trade agreement to enable that will be the ones that will produce this evolution of the likelihood over time that a U.S. investor would be treated fairly in courts in Mexico, for example, than the provisions specifically of the trade agreement itself.
I would also say it's really not either or. I think many U.S. investors in Mexico and in other markets will use the domestic court system for certain disputes if they think that's a possible avenue to resolve them. So this is really, there's specific investment protections provided to U.S. investors under this agreement. You know, this provides a neutral enforcement mechanism for an investor to be able to bring those claims. But if they have claims under domestic law, they may very well be pursuing them. So I don't think that that it's an either or. I think that if you have robust investment in Mexican economy, then some of those U.S. investors are choosing the U.S. courts to try to resolve these disputes. But it's important that if that's not working for them, you don't force them to wait it out for 2.5 years. Why can't they make the business decision and their own judgment call based on the facts to decide how best to navigate that for them? This takes a lot of important C-suite level business decision making about disputes out of the hands of individual companies.
Yeah, I would echo Marnia in that I don't think it's either or. I think, especially if you've got a lot of capital invested in a particular market, it's a very complex investment, and there's numerous pieces of regulation that your investment might be subject to, whether it's safety, whether it's about how you manage or transport chemicals, and you know, these are investments that are supposed to last the test of time. They're not there for just 1 year. I mean, many of our companies are making investments that have very long time horizons. So I think that ISDS it's an option. It should be an option that investors can use if they feel like their problem is not being addressed. But for political reasons, locally, you would want to take issues to the local courts because maybe that's the right avenue. I think Marnie got this one right.
Let me pick up on that point. A lot of the kinds of investments we're talking about are meant to be long-term investments. They are meant to stand the test of time. And often if the investor has agreements with either the central government or a local government, its goal is not to pull up its stakes and cash out and leave, but to find some solution that will enable it to stay, to some way through that will cause the government to change its conduct and enable the investor to stay. And some might say that resolving disputes in that fashion is the province not of investor-state dispute settlement, where the only remedy is a cash payment of damages at the end of the day, but state-to-state dispute settlement, where the goal is to remove the offending conduct if that's in breach of an obligation under the agreement. So my question to the panel is, with this quite dramatic alteration of investor-state, would you expect to see a blossoming of state-to-state dispute settlement under the USMCA in situations where the investor has legitimate grievance, doesn't want to cash out and pull up its stakes, but would look perhaps to its home government to intercede with the host government with a view to resolving that, much like we do with trade disputes in the WTO? Thoughts on that?
Market economies are incredibly complex. And I think that as a result of that, the bar is very high for a sovereign government to act on behalf of an individual investor, however egregious the treatment may be that that investor is facing in a foreign market that may be discriminatory in nature toward the foreign investor, a U.S. investor in another country versus a domestic investor. So I think it's probably unlikely that we'll see more state-to-state disputes and settlements sought by the United States on behalf of individual investors, because that requires the expenditure of investment of time and resources by people who work for all of us. And there needs to be a clear-cut case that the national interest is at stake at such a level to justify the use of federal government resources in order to pursue a settlement through dispute mechanisms. It may be that over time there's enough of a collection of these that might push the beyond the threshold of justifying state action. But I think we could imagine that that's going to be difficult to see and marshal over time at the scale that would prompt a justification for state resources to be spent in that way.
Also, if it's the burden is on the state to bring the dispute on behalf of the investor, then it's subject to the broader political relationship between those two countries. There's a lot on the table between the U.S. and Mexico right now. Whether your investment dispute ranks high enough to become part of that mix, even if you have a very meritorious claim, it just might not be the right time for the U.S. government to advance your claim. And I would give Russia as an example. I work on many disputes adverse to the Russian Federation. Some of those are on behalf of U.S. investors. Some of them are on behalf of Ukrainian investors. The U.S.-Russia relationship and the Ukraine-Russia relationship are very complex. In the U.S., there's no investment treaty. There's no way to bring an investment claim against against Russia for U.S. citizens. And so those investment disputes are not being brought because the relationship between the U.S. and Russia is too fraught for the U.S. to step in and advocate for their investors, even if it was a slam dunk. And so to have investors who may have meritorious claims not have access to this enforcement mechanism, I think does those investors a disservice, because the U.S. government's not always going to be able to or want to advocate for a specific investment.
Thank you. This has been a really interesting conversation. We'd like to open it up to the room, take questions. We have a mic runner. He's going to come around. Remind folks the WITA ground rules. Please identify yourself, your affiliation, and to please ask your question in the form of a question.
Hello, Michael Smart, Rockwood Global Advisors. I want to try to put a fine point on your discussion on Annex 14E. This is the 5 special sectors that get to go to ISDS for all claims. Based on your discussion, and as I've looked at this, it's actually coverage of one part of one of those 5 sectors because of the government contract requirement. It's if you're an upstream E&P company in oil and gas, as Aaron explained, you have that contract with the Ministry of Hydrocarbons. But are any of you aware of investors in any of those other sectors that, as a matter of course, enter into contracts with the federal government of Mexico and therefore can trigger that access to ISDS?
Yeah, I wouldn't say I've looked at this exhaustively, but I have looked at it, and it's not clear to me that there is like a broad class of U.S. investors that certainly benefits from this, besides those that would be able to check the box of having, some kind of government contract or concession agreement with the federal government.
I'd also like to clarify our interpretation of it for natural gas and oil. I offered the example of an exploration and production or upstream illustration of an agreement with the National Hydrocarbons Commission as a likely clear-cut example, but it's not the only one in our view. There are likely other examples of such covered agreements that our members will argue make them eligible for ISDS for their other investments in Mexico that may not be upstream, may not be subject to needing to enter into an agreement only with the National Hydrocarbons Commission. And plus, there's the keyhole provision that provides them eligibility for any such natural gas and oil investment of any kind in Mexico if you have a covered agreement for at least one of your investments. So in our view, there's quite a broad coverage of natural gas and oil beyond just the one example that I used to illustrate.
Thanks, Tom Cunningham with Equinor. Two quick questions. One, what's the implications in terms of precedent for this change in ISDS? I think about future trade agreements between developed countries or between developed and developing economies. Especially in the latter, I think ISDS would be important, and not just in the niche of sectors discussed. And second, what's the potential for revisiting this in the future iterations under this renewal process that USMCA has?
As an ex-negotiator, think about how little leverage the United States would have in future trade negotiations. If a trading partner said, well, we don't really want ISDS, you gave this deal to Canada, so therefore, you set a precedent. I think it's a little bit worrisome that trading partners might take that perspective. I'm sorry, what was the second part of your question?
The second part is, under this new USMCA, it has to be revisited by
yes.
all three parties, sort of in a regular way, and that's to refresh or keep updated the agreement. Therefore, one could argue that this could be reinserted at that time if the leverage or the chessboard changes.
Well, I hope that's the case, but I think there's a bit of a mismatch in terms of the timelines. I mean, Canada, after 3 years, is out, but then the performance review of the agreement is at 6 years. So what incentive at 6 years does Canada have really to opt back in at that point when they've already opted out? So, I mean, one real practical suggestion here is lengthen Canada's opt-out time to 6 years as opposed to 3.
When you talk about the precedent and whether this is now the new template, longstanding U.S. practice has been that if we're going to shift the template for investor-state dispute settlement, that it should be done through a robust consultative process that results in a model bilateral investment treaty for the United States. Several administrations, both Republican and Democrat, have gone through that model U.S. BIT process, the most recent, the 2012 model U.S. BIT. These provisions look nothing like the 2012 model U.S. BIT, but the consultation process to get there didn't exist in the same way. I think that's why, people, what's this government contract provision? I don't know. Can I make a government contract and have huge access? I don't know. How big's the keyhole? If there was a methodical process to get us to this new model, I think some of these issues and the implications of these issues across U.S. sectors could have been fleshed out. So I would hope that before this becomes, quote, a new U.S. model, that we go through the same methodical process that we have in the past to try to reach consensus on whether this model is going to work. In terms of whether it can be revisited, sure, as we can see, NAFTA 2.0, like, what are those, like, iOS releases, like 2.1A or something. I think 2.01, okay. I think we could always revisit it, right? We could decide it's not working. But frankly, in this lead up to possible approval of this agreement, we also can decide that this isn't going to work. I think you saw with the U.S.-Colombia Free Trade Agreement and others, I mean, sometimes there's a deal that maybe made sense at the negotiating table, but doesn't make sense now. So I think there's arguably might be still time to revisit it, but I think that going forward, either through that formal renewal process or otherwise, I mean, if it turns out this system isn't working and there's pressure to fix it, that at least everything's possible. Will it be easy? No, I would agree with that. It wouldn't be easy, but it's certainly possible. There's mechanisms to do it.
add one observation to what Marnie said. One of the benefits to this quaint, old-fashioned idea of consultation that we used to have and to coming up with a model is that it keeps to a minimum some of the MFN kind of issues that would come up if you do one variant of the investment agreement here and a different variant there and a different variant here. And you know, if we're not going to do that, if we're going to have one version of investment for the USMCA and a different version of an investment chapter for the next party to come along, there is that risk of unanticipated MFN issues arising.
Hi, Jen Riccardi with the European Union. It's my understanding that one of the NAFTA parties proposed ISDS with reference to an investment court similar to what was agreed in the CETA agreement. And my question to the panel is ISDS with a different type of neutral forum preferable to no ISDS? I know Ted's answer.
I'm a skeptic of how this investment court will work, and I look forward to watching how Canada and the EU try to work it out. I don't know that to the extent it's meant to address some kind of concerns about how the ISDS system works. Frankly, those types of issues weren't really the issues that were most controversial for NAFTA 2.0. NAFTA 2.0 does have broader transparency provisions. It does have broader obligations on arbitrators to ensure a lack of conflicts. It does have provisions for non-disputing party and amicus participation. So on some of those transparency points, we've modernized NAFTA, and I think those can address some of the concerns about transparency, conflicts, etc. So I don't think, my own view is that an investment court, if there is a revisit, I highly doubt you're going to see an investment court as the end result.
Just a follow-up to Jen's question, though. Everybody talked about the fact that Canada is not part of this system, and Canada is an advocate of this investment court idea that has been, you know, memorialized in the Canada-EU trade agreement. So, as a hypothetical, if the choice here had been an agreement in which Canada, as well as Mexico and the United States, is a participant, and no sectoral restrictions, but kind of institutional structures that you have in the Canada-EU agreement versus what we have in USMCA Chapter 14, I'm interested in the views of the panel on which would have been preferable, given those two alternatives.
That's a hard hypothetical. I think there's one thing we did not mention, though, is that Canada, correct me if I'm wrong here, but I believe Canada took full ISDS with respect to TPP. And I mean, that I think would have been a far more preferable model for the United States if the United States stayed in TPP and we would have had full access. I hope we can revisit that as opposed to considering a sort of a new investment court, a la CETA.
Our members are skeptical, mostly on practical grounds, of the efficacy of a CETA model, investor dispute settlement mechanism versus traditional U.S. model BIT, ISDS. But I think we can at least see that the U.S. and the EU and Canada are aligned, at least in what we've seen between Canada and the EU, and the way in which the EU has continued to advocate for a dispute settlement mechanism for investors in wanting to see that as a part of trade agreements. So let's let some time play out. The combination of the transparency provisions in the USMCA that truly are modernizing, that address a lot of critics' claims of kind of sort of discontent with it, alongside the CETA implementation and disputes that are brought under that mechanism, and let's just view it in the terms of what's practically working. And then maybe that can involve all of our understanding of what might be the ideal setup for this sort of a mechanism in the future. But the most important thing that we've all agreed on is to retain it and to retain the benefits that it conveys.
And I would just say, I think right now there's probably a political impediment to the U.S. government seriously considering an investment court, and that is if what we hear is correct, the policy rationale we hear is correct, is there's a lot of concern that investor-state dispute settlement mechanisms are an affront to U.S. sovereignty, and ceding kind of sovereignty to an investment court rather than deciding that you'll carve out more disputes for a state-to-state dispute settlement mechanism. I think the idea of creating international institutions is not kind of where this administration is right now.
Barbara Bowie Whitman, in attending several panels and seminars about the new NAFTA, the general question that it comes down to in the end is whether we're better off with something we may think is not as good as what we had before, as opposed to not having anything. I think on the whole, people think we've got to have an agreement in some form or shape. So I asked a question at an automotive panel at Heritage last week as to whether their sector would be supporting this in terms of getting it approved. And the answer was, we don't know yet, we're still thinking. Do any of you have an overall view, given that each of you has expressed serious reservations about this aspect of the new agreement? Do you know where you stand on should it get approved?
API fully supports the new USMCA. With regards to investment and some other provisions, it's not an exact alignment with our preferred policy position, but it's sufficiently aligned such that we support. And that's weighed against the range of issues and just looking at the pure substance of the agreement itself in comparison with what other point of reference you may pick. And it's also precisely against the scenario that you outlined of what would it look like for our members' interests and for U.S. energy interests if there were no NAFTA, if there were no USMCA. This administration has signaled a serious intent to consider a unilateral withdrawal from NAFTA without having a successor agreement in place. We take that seriously. We don't think that that's good for U.S. interests, however you may characterize them. So we're glad that there's a successor agreement that reflects the provisions that we've all been discussing, that for our members are sufficient for us to be able to fully support it.
Yeah, from the perspective of the American Chemistry Council, the agreement that we have in front of us may not necessarily be the agreement that the administration sends up with the implementing legislation. This agreement isn't even signed yet. I think there are changes being made to it. In this, maybe not in this area yet, but perhaps in other areas. So between now and when Congress actually takes a vote, I think there is time and space to make improvements to this outcome, and that's really what we're shooting for. As I said at the outset, there are a number of wins for the U.S. chemical sector that we really, really like. We want to make sure that this meets our interests as well.
Thank you for the panel. Ellen Ferguson, CQ roll call. I have a very narrow question. You talked about maybe revisiting some of these provisions, particularly ISDS, in Congress in the implementing bill. What effect would there be, do you think, if the Democrats actually take the House, since this has been an issue where they have cited as a problem for manufacturing and for the unions?
I think that this agreement has a complicated path to approval in Congress, and that path gets even more complicated if the Democrats take the House.
I'll offer an answer that speaks to the narrow subject of the investment chapter in USMCA and the way in which Republicans and Democrats have expressed their views on this. I think it's important to remember that there are many significant Democrats that have supported and called for investment protections in ISDS and U.S. trade agreements and expressed that preference in their vote in support of the Trade Promotion Authority legislation in 2015. In our conversations on an ongoing basis with Republicans and Democrats alike, we believe that there's a strong bipartisan understanding and support for investment protections in ISDS. And I would probably argue that the provisions that they're looking at in the Chapter 14, the investment chapter of the new USMCA, speak to much of what they equally would like to see retained. There's greater emphasis by Republicans on some provisions and by Democrats on others. But on the whole, it addresses many of their concerns that they share or that they differ in prioritizing. Our support for it comes with the support for those provisions across the board. And it offers us potentially with an opportunity to re-rationalize the whole discussion around these provisions in a trade agreement, and then work to build back up from here, a case for the fuller and the simpler ISDS eligibility that we've been accustomed to on the basis of a baseline and an experience that we'll all be able to reflect back on as the USMCA probably comes into force and plays out over time.
The only thing I'd add to what the panel members have just said is, first of all, I agree with Marnie's observation that the path to congressional approval is going to be a long and convoluted path. Bear in mind that there's unlikely to be any particular provision in the implementing legislation that deals with investment or investor state. There's no changes to U.S. law that would be necessitated in order to implement those provisions of the FTA. However, recall, or some will recall, the famous May 10th agreement. The last time we had a change of Congress, a change of the majority in the House, and we're considering approving FTAs that were then on the docket, including Colombia and Peru. So query whether, to your question, we're in for another May 10th type agreement with respect to investment, should there be a change in majority.
Thank you very much. Thanks to our panel. Thanks to all of you. Remind you about WITA's upcoming events. It's all in your packet that you got today, including Ambassador Grosser event Monday. I want to just flag that again because it's free for WITA members, but you have to register and you have to do that in the next 24 to 48 hours because we have to get all the names through security. WTO event next Thursday as well. Here in the Reagan Building, and then EU-US trade the week after, and look at Brexit. Thanks again to our panel. Really terrific discussion. Very grateful to all of you. Thank you so much for being here, and thanks to everyone else.